Mettiamo in pausa magari la registrazione. Yes, of course. And one of my preferred matter is the family law. So I suppose that this was one of the topics that I have the possibility to speak about the family law in every part of the world. So it's a very good occasion to debate this argument in a so very interesting conference from Juris Diversitas and from the different point of view. Well, the first speaker will be Raeda Hamien, that is professor at law faculty of University of Cape Town, and she's very, very famous because she wrote very, very a lot on family law and a big number of work and paper on this argument. So please, Raeda, start your argument.
Thank you very much, and good afternoon, everyone. I would like to thank the organizers of the Juris Diversitas conference for affording me the opportunity to share some thoughts with you all. At the outset, I should let you know that I'm a member of the South African Law Reform Commission Advisory Committee on the review of matrimonial property law in South Africa. So the views that I express in this presentation are in my personal capacity, and they are not necessarily those of the South African Law Reform Commission or the University of Cape Town. In this paper, I consider recent law reform efforts by the South African Law Reform Commission Advisory Committee on the drafting of a single marriage statute, so not the committee that I sit on, and the Department of Home Affairs' proposed reforms of marriage policy in South Africa. As a constitutional democracy, South Africa is governed by a constitution that contains a Bill of Rights, with which all law and conduct in the country must be consistent. Among others, the Constitution recognizes the rights to equality, including the right not to be discriminated against on the basis of, among others, religion, sex, gender, and marital status. And the Constitution also entrenches the right to dignity, as well as the individual and collective rights to freedom of religion and culture. Now, while the Constitution does not recognize a right to marry and form a family, it does make provision for the recognition of different forms of marriages, including traditional and religious marriages. Due to South Africa's fractured history, marriage laws in the country have also developed in a somewhat splintered manner. We have at least 3 pieces of marriage legislation that recognize and regulate 3 different kinds of marital relationships. There's the Marriage Act, the Recognition of Customary Marriages Act, and the Civil Union Act. The Marriage Act makes provision for the registration and regulation of civil marriages. It requires that the relationship must be monogamous and heterosexual. The Civil Union Act also requires monogamy, but enables same-sex unions to be registered. The Recognition of Customary Marriages Act allows heterosexual, monogamous, and polygynous customary unions, where a husband can take multiple wives. Many of the requirements and consequences of the Customary Marriages Act are similar to those of the Marriage Act and the Civil Union Act, but certain features that are particular to customary marriages are accommodated, such as lobolo, which is the giving of bride wealth, and polygyny. But religious marriages and domestic partnerships are not yet legally recognized in South Africa. The South African government has initiated 2 processes with the intention of harmonizing the marriage laws in the country. The one process is led by the South African Law Reform Commission Advisory Committee, and the other by the Department of Home Affairs. The South African Law Reform Commission proposes draft legislation to recognize and regulate the registration only of various types of intimate relationships. At this point, they are proposing that the relationships should be described either as protected relationships or marriages and life partnerships. So it seems that they're wanting to afford recognition to monogamous, polygynous, heterosexual, and same-sex relationships, including religious and customary marriages and life partnerships. But the Law Reform Commission's definitions of protected relationships, marriages, and life partnerships, for whatever reason, doesn't include polyandrous and polyamorous relationships. So polyandrous, where a wife has the right to take multiple spouses, and polyamorous, where one person enters into multiple relationships with other people, so regardless of gender. It's unclear why this is the case, because it seems as if the Law Reform Commission has taken an approach to try to be as inclusive as possible. Now, their proposal also focuses only on recognition and registration of intimate relationships. They expect that the consequences of intimate relationships should be dealt with in existing legislation that addresses, for example, matrimonial property, like the committee that I'm sitting on at the moment, guardianship, custody and access of minor children, dissolution of marriages, and the winding up of spouses' deceased estates. So it basically means that several other pieces of legislation will need to be amended to accommodate the diverse family forms in South Africa. Now, the Department of Home Affairs recommends 3 options to reform marriage laws in South Africa. The first option is enact one piece of legislation, which they will call the Single Marriage Act, and that will contain the same requirements and the same consequences for all forms of intimate relationships, regardless of the nature of the relationship and the features of the relationship. The second option is to enact what they are calling an omnibus legislation, which would be one piece of legislation but containing different chapters. And each chapter would make provision for a different type of marriage. And so this kind of initiative could include chapters for existing marriage legislation and include new chapters for new legislation to recognize different religious marriages and domestic partnerships. Or the third option is simply retain the status quo and enact additional legislation to recognize religious marriages and, of course, also domestic partnerships. But the Department of Home Affairs' proposal doesn't include domestic partnerships yet. Now, South Africa is a heterogeneous society, and it comprises a diverse range of religious and cultural communities. And within those communities, many different kinds of intimate relationships are entered into that are monogamous, polygynous, heterosexual, same-sex, and even non-binary in nature. Oh, has my slide gone? Hello?
It's still visible.
My screen is paused. I don't know what happened. Okay, let me try and share again. Oh, okay. I know what happened. We've just experienced load shedding. So I'm afraid I'm going to have to proceed without a slide unless Krista, if I can send a slide. Well, let me continue. So the main challenge that legislators face is how to balance the constitutional imperatives to respect diversity on the one hand and ensure substantive equality, including gender equality, on the other hand. Now, if one considers a religious diversity management spectrum, and so the slides would have been nice to illustrate this, marriage laws could either promote assimilation or accommodation or integration. Now, when I talk about assimilation, I mean a process that involves a marriage regime having to fit in with the requirements and identity of what is considered to be the mainstream marriage regime. And so the proposed Single Marriage Act would be an example of assimilation and would most likely entail one piece of legislation being enacted to afford recognition to all types of marriages, whether they're civil, religious, customary, heterosexual, same-sex, non-binary, etc. And such a piece of legislation would include the same requirements for all types of marriages and would most likely regulate all types of marriages and divorces in the same way and possibly involve the same consequences for all types of marriages and divorces. As an example of an assimilation approach, I argue that the Single Marriage Act is normatively problematic for 5 main reasons. The first reason is that in the context of a religious marriage, the religious identity of the marriage could be lost in a public state-regulated domain. In other words, the nuanced features of the marriage are not regulated. And this means that religious rules and practices, especially those that are discriminatory in nature, cannot be held accountable to norms of equality and justice within a state-regulated domain. And in particular, the assimilation approach does not have the potential to take into account and be responsive to the nuanced features of different types of religious marriages, which then could have a disparate impact on marginalized members of religious communities such as women. So an assimilation approach potentially bears negative implications for the rights of women. Secondly, a proposed Single Marriage Act will promote assimilation of the religious identity of the religious marriage and religious divorce into the common law identity of a civil marriage and a civil divorce. And both of these are underscored by a Western Judeo-Christian paradigm of marriage, which is entirely inconsistent with the ethos of legal pluralism and the celebration of diversity, both of which are promoted by the South African Constitution. The third challenge is that while the proposed Single Marriage Act may meet the requirements for formal equality, that likes should be treated alike, it won't promote substantive equality, and that is the approach to equality that is consistent with South Africa's constitutional imperatives. Because if the impact of equal treatment results in inequality, particularly where the inequality exacerbates disadvantage among marginalized members of society, such as women in religious communities, then the differential treatment is justified. Religious rules and practices, particularly of a discriminatory nature, will not be able to be regulated through a Single Marriage Act and could continue unabated within religious communities. For instance, a Single Marriage Act will not enable women in religious marriages to obtain religious divorce, which many women have difficulty accessing in South Africa. And in this way, a Single Marriage Act will not be responsive to the lived realities of all women in South Africa, which is an imperative of substantive equality. Fourthly, lack of regulation of the features of the different types of marriage and divorce will allow the judiciary to invoke what we call the common law doctrine of religious entanglement. And this prevents a judge from engaging with religious issues, and it can be used as a shield to shield religious rules and practices that negatively impact on women. The last main reason that I advocate is that the proposed Single Marriage Act assumes that the state has no responsibility to protect marginalized members within communities against harmful practices within those communities, and it in fact ignores the private and public nature of the consequences of marriage. Our Constitutional Court has noted that marriage brings the most intense private and voluntary commitment into the most public, law-governed and state-regulated domain. Marriage is thus deemed to be constitutionally significant because of its private and public importance. And so to not bring religious marriages into the public, state-regulated domain where they can be held accountable to human rights standards underscored by the foundational values of the Constitution, namely dignity, equality and freedom, would mean that discriminatory religious family law rules and practices can remain hidden in the private sphere, which perpetuates privatized oppression. Examples of these types of practices include the inability of women to access religious divorce or to be compensated for their contribution within a religious marriage. So that was the Single Marriage Act. Now, the second type of proposed legislation, which is the Omnibus Marriage Statute, could incorporate either an accommodation approach or an integration approach. Accommodation could involve the state guaranteeing a sovereign sphere of decision-making to the religious community. In other words, legislation could be enacted to provide blanket recognition for all religious marriages, but leave the regulation and the management of those marriages to the religious communities. And so what happens is that the identity of the religious marriage remains intact without necessarily having to conform to human rights standards. A comparative example is India, where the accommodation approach has arguably not afforded sufficient protection for the rights of women. For instance, India's Muslim Personal Law Sharia Application Act affords blanket legal recognition to Muslim personal law and enables the Indian Muslim communities to regulate Muslim personal law themselves. This has resulted in discriminatory Muslim family law rules and practices receiving legal sanction, including at the High Court level in India. And it is only when the matter reaches the Supreme Court level in India that the judiciary intervenes to protect the rights of women. So an omnibus marriage statute that seeks to only accommodate different forms of marriages without regulating their specific features could have similar implications as the assimilation approach. For instance, an omnibus marriage statute that purports to afford blanket recognition to all forms of marriages creates the risk that discriminatory religious rules and practices continue unabated within the private sphere. And efforts to hold those rules and practices constitutionally accountable may be hindered by the South African common law doctrine of religious entanglement, as is the case with assimilation, where the judiciary could take the position that they cannot interfere in religious family laws since the legislation itself leaves regulation of those laws in the hands of the religious communities, which means that a single marriage statute that embodies an assimilation approach and an omnibus marriage statute that encompasses an accommodation approach potentially offers more protection for freedom of religion than gender equality. Now, in contrast, the integration approach expects a religious marriage to be legally recognized within a human rights framework. Integration involves recognition of and respect for religious diversity within a framework of equality. To achieve this integration, integration requires regulation of the features of different forms of marriage and divorce within a human rights paradigm. In 2020, the South African Supreme Court of Appeal confirmed an order for the enactment of legislation to recognize and regulate the consequences of Muslim marriages. So an omnibus marriage statute that incorporates an integration approach would give effect to the court's judgment, especially in relation to Muslim marriages. And this could be achieved through the inclusion of chapters that each purport to recognize and regulate the features of different types of marriages. So within the auspices of an integration approach, an attempt to balance freedom of religion against equality or with equality usually happens. But since the drafting process for legislation involving an integration approach also usually involves an attempt to balance varying interests within society for political reasons, the resulting legislation may not always provide full protection to all human rights. But at the same time, by regulating the features of religious marriages, the features are also brought within the purview of the judiciary. And so the judiciary is then authorized to interpret those features of religious marriages that the statute purports to regulate. And it is therefore highly unlikely that the common law doctrine of religious entanglement could be invoked in those circumstances. Now, through an approach that I call the gender nuanced integration approach, the judiciary is identified as an important role player for the protection of human rights in the context of religious marriages. Unlike the legislature, which has to, among others, consider competing interests, the judiciary is required to focus on the protection of human rights. Where necessary, the judiciary must ensure that religious freedom is not protected at the expense of gender equality. So my argument is that an integration approach has greater potential to offer more protection for substantive gender equality than the assimilation and accommodation approaches. Some religious marriages may require more or less regulation than others. And so this is why I believe that a one-size-fits-all approach in South Africa won't work. So for example, in the South African Muslim context, my research has shown that comprehensive regulation of the consequences of Muslim marriages may be required. But in the South African Jewish context, on the other hand, it may be that only the ketubah, their marriage contract, needs to be regulated to ensure that Jewish women can access a Jewish divorce, which is the get. And then in the South African Hindu community, it may simply mean giving Hindu spouses access to a civil divorce in instances where they enter only into a religious marriage. So there's no one-size-fits-all solution. I believe that the solution lies in being attentive to and responsive to the nuances and the challenges of the different communities in South Africa. I thank you.
Thanks, Leda. Very, very interesting presentation, and it's a good occasion to know about the South African system, and I mean also that this is a problem that is very, very common in every part of the world, because people think that probably people and legislators think that the law is a way to control the society, but I suppose that is practically impossible, especially in family matters. But we have a discussion just in a few minutes. Okay, now we start the second presenter. That is Professor Pace, that is Associate Professor of Tax Law. In Italy, when we speak about the tax, I think that's the same in some part of the world, but when we speak about taxation, we are very, very afraid of that. I remember that 2 years ago, I participated in a meeting with a colleague of mine that was professor of robotics, and he showed us a fantastic robot that was an actress, and she played on the stage. And I asked, okay, but what do you think, my friend, is any possibility that the state will consider a robot like a human person? And he told me, I am not sure about that, but I'm sure that the state will tax on it. And so, Annalisa, the floor is yours.
Thank you. We are terrible. Good afternoon and good evening, good morning, everybody around the world. And let me thank the organizer, of course, and say a specific goodbye to a very nice colleague, Professor Castellucci. Is of my University of Teramo, and is a very, very good, professor, and is a very good friend. My presentation is focused about the fiscal perspective. I am in this panel, the dark side of family law, but my presentation is about the fiscal perspective. Let me do a short introduction, because I have to clarify that family in its multiple forms is the central structure of our society, and the usual importance of family is testified from decades of sociological, economic and legal structure. Nevertheless, the tax systems forget this important aspect and often places burdens on families without taking into account the obligation of assistance and maintenance of taxpayers. Well, the Italian system is a perfect example. The tax lawmaker approach shows suspicion of family and of its component, and if they were siblings against authorities. It may seem incredible, but when the tax lawmaker is occupied with family, the consequences are often not positive. Many institutes do not promote and assist family and family birth, but on the opposite side, aim to dissolve the familiar relationship and penalize them. The personal income taxation, with its progressive tax rates and in view of the fact of its inability to take into account the familiar costs, make it more convenient for two spouses to separate, and this creates the odd phenomenon of separation divorce for tax purposes. The examples are numerous, and I'll show you with my presentation. Can I share my video? Okay. Can I, one moment, okay.
We can see your
Yes. I want to use the different presentation.
Okay, you want to
I can't. Okay, no problem. No problem. It remains so. So sorry. I'm sorry, but I can't. No. Present. Oh wow. This is this. Okay. No. The toolbar presentation. Okay. Oh yes. Well. Family is a value for the society, I just said, and it is testified in our constitutional chart, in the constitutional chart in general, and in our constitutional chart in particular. Article 29, 30, and 31 define family as a natural society based on marriage that must be protected and facilitated. But what is the role of family in a fiscal system? Every country with an income tax system have to choose the definition of a taxable unit, the so-called taxpayer, the robot, for example, for purposes of linking the taxable income to a specific subject. Well, we have two possibilities. The alternative is between an individual model and a family one. Well, the individual model, or also it is called separate taxation model. Each physical person is a taxable unit, and everyone has to file tax returns, declare taxable income, claim expenses, and of course, pay income taxes. The other model, under the family model, the family is the taxable unit, and each individual is treated as part of the family. And the family is thus required to file a tax return, declare income, claim expenses and deductions. Well, around the world, we find individual models, for example, in Australia, Canada, Italy, Japan, Russia, Sweden, and the United Kingdom, and family model, the well-known family quotient in France, while Germany and USA have a hybrid solution with an individual system and a splitting system. In this case, the married couple can opt to file a joint return. Well, in Italy, we find an individual model, but it takes into account the participation of a family. It is a relevant element, and this aspect is taken into account with different systems, for example, deductions or tax credits. Well, this is the general frame, but when we go deep, the result is that we perceive a weird approach of the tax lawmaker. In which sense? Well, the tax lawmaker attention to the family is a sort of obsessive and diseased attention. Why? Because the paradigm is for the tax lawmaker, but for the office, for the fiscal office too, and for the judge too, that taxpayer is a possible tax evader, and family is the place, is the better place where evasion is real. So, in other words, we can say that for the tax lawmaker, family equal evasion. And thanks to the bonds among their members, in the tax law vision, family is a very good place to evade and avoid taxes. And we can find more rules to fight evasion in family situation than rules to protect and support families. I prepared some examples to make too easy to understand better. The first example is about family business. Family business is a particular institute and is born in the civil law, where as the target to protect and support the weak members of the family who work in it, and is characterized by freedom of form. Well, in the tax system, we can find a regulation of this institute, but we can find a strict regulation which has the only target to avoid a splitting system for the incomes of the company. In particular, the rule, we can find the rule in the Italian Income Tax Consolidation Act, the Article 6, we can read together. It says the income from family businesses limited to 49% of the amount of income declared by the entrepreneur is applied to each member of the family who worked continuously, mainly in the enterprise, in proportion to the share of each in the profits. In other words, the 51% of the income is applied to the entrepreneur and only the 49% to the other members without possibility of a different apportionment. So I prepare a simulation. In the simulation number 1, I suppose to have a family business composed of 2 spouses, 3 sons, and grandmother. And the income at the end of the period will be 120,000 euros. Well, without Article 5, we would free to share the income as we want. For example, we can divide the entire income 120,000 euros among the 6 members. So each of one will have 20,000 euros. The taxation will be with progressive rates of IRPEF. On the first bracket, 15,000 euros with 23%, 3,450 euros. And on the second bracket, for 5,000 euros, we apply the tax rate of 27%. The tax will be 1,350 euros. In other words, the total of taxation in this situation will be 28,800 euros. Well, in the second simulation, we have the same situation, the same family business composed of 2 spouses, 3 sons, a grandmother, with the same income of 120 euros, but we have to apply the Article 5. Well, we have the 51% of the income will be attributed to the entrepreneur, and only the 49% will be attributed to the other members. So the calculation is very different because the entrepreneur will have 61,200 euros taxed with progressive IRPEF, and the total taxes will be 19,762 euros. In the second spouse, we'll have, for example, 28,800 euros. So the taxation will be 7,264 taxes. The first son and the sixth son will have 15,000 euros. So the taxation will be 3,450 euros. And, but the third son and grandmother will have nothing because they work in the, I suppose they work in the family. And the tax lawmaker don't recognize the work in the family, but recognize only the work in the enterprise. Well, the total of taxation will be 33,836 euros. Here is a summary to compare the two situations, and it is clear that the family business in the example 2 with the application of Article 5 pay the taxes of this in this example is significantly higher than in the first example. Well, other example, the rules present the same approach. For example, for the remuneration for spouses, sons, and other relatives, the tax lawmaker do not consent the deduction of this cost. In particular, for self-employment income, Article 54, paragraph 6b of the Income Tax Consolidation Act says deduction shall not be permitted for remuneration to a spouse, sons and daughters, adopted persons, persons subject to custody, minors or thus unfit to work, as well as the ascendants of the artist or professional or partners or associated for the work provided or the work done for the artist or professional or for the company or association. Remuneration non permitted for deduction shall not be included in the total income of the recipients. In other words, the artist or the professional can't deduct costs to remunerate the work of their relatives, even if the work was actually done. In other words, there isn't the possibility to prove the contrary. And the same rule is for business income. Article 60, entitled Expenses for Work Service, says compensation for work performed by the entrepreneur, spouse, children, minor age or disabled wards or affiliates and ascendants, or by family members investing in the enterprise pursuant to paragraph 4 of Article 5, is not deductible. It's the same. Well, what is the underlying idea? Well, the underlying idea is that in this situation, the family bond can be used to create fictitious cost, probably yes, to lower the tax base and to pay less taxes. So in the balance between, we can say that in balance between public revenues and protection of the family is the first to win. We have other example for a small family company. What is a small family company? It is a company in the hands of a small family group. In other words, with few members and that present very close relationships. I need to make a clarification, because in Italian system, we can find two different models of taxation between partnership and companies. Because for partnership, we have to apply the so-called transparency principle. In other words, the profits of the partnership are taxed towards the business partners independently of any receipt. While for the companies, the rule is different, and the taxable income is the income of the society, and the dividends will be taxed when they are distributed to the participants. Well, when the fiscal office verifies higher incomes against a company, they use the Article 5 and the rules of transparency principle. In other words, income is attributed to each partner independently of any receipt in proportion of the percentage of the participation in the profits. Why? Because in this case, the higher income is considered earned by the members of the family who have in their hands the company, and the office must not give any evidence of this statement. In other words, there is anymore an underlying, and there is, one more time, an underlying idea. In this situation, the partners who are members of a single family and have very close relationship must know the existence of hidden income, and there must be a hidden distribution of profits without a contrary proof. So in a company which is in the hand of a small group, with a small group composed of relatives that show very close relationships, they act for a common purpose, that is pay less taxes. Yes, the Italian, I have 2 or 3 minutes Yes, we have the Italian fiscal system presents many distortions too. We have just said it is an individual model. In other words, each physical person is a taxable unit, and therefore everyone has to file tax return, declare, pay, and so on. Well, it takes into account aspects of the family as a taxable unit model with deduction or other system, or for example, tax credits. Well, tax credit, Article 12 of Income Tax Consolidation Act, grants a tax credit to the household for dependent member. In other words, the member who have no income or limited taxable income. Well, when the member of the family exceeds when the member of the family has exceeded that limit, that is very low, only 2,850 euros, the increase in gross income produce a reduction in net income. And another problem is that when the household has not enough gross taxes to use the tax credit, they lose it because there is not a negative tax system. In other words, I mean that in this case, the part of tax credit that doesn't find capacity in the gross tax will be lost. Yes. We have individual system of income taxation present other problems. In particular, it encourages evasion phenomena. Examples are allocation of movable and real estate income to the members with lower income. And in this way, they obtain an important taxes reduction. In other words, they use a sort of handmade splitting. And in conclusion, we can remember that this system encourages fake marriage separation. In Italy, 7% of marriage separation are false and have the target to obtain fiscal advantage. Let's prepare a simulation. In this case, we can see that we have a family A, in example 1, with 2 spouses, and only one has an income, I suppose 70,000 euros. Well, the income tax will be 23,370 euros. But suppose the spouses separate. Well, in the second example, the same family with 2 spouses and only one has an income of 70,000 euros. Thanks to separation, judge condemned spouse A to give to spouse B a spousal support of 20,000 a year. Well, spouse 1 has an income of 50,000 euros and taxes for 15,320 euros. Spouse 2 has 20,000 euros and 40,800 euros of taxes. So the total taxes will be only 220,120 euros, and with a tax reduction of with a tax reduction of 3,250 euros. In conclusion, in the fiscal system, the prejudice of tax lawyer is not good for family, and this strict approach and the limitation of fiscal system are not good for family. And the hope with which I desire to conclude this meeting is to look to the family as a resource and not as a terrible burden. Thank you. This is the end.
Excellent. Thanks a lot. I think that, brava. I think, Annalisa, that you give us the point, because just until a few days ago, I remember that one of our most important judge just going to retirement said exactly this phrase. There are this sentence. There are no innocent, but only criminals that are not yet discovered. And well, I think that this is not a good background to approach to the family law or in general taxation law. But you know, I think also that the tax system is very important to increase or decrease the possibility to have a maternity, the possibility to have a distribution of assets. I mean, a succession law that now it's in Italy is under pressure, and so on. I don't know if a good idea to go married now, but well, from the point of view of the tax system, probably no.
Probably no. Probably.
Yeah, sometimes I think that the advantage are better than the disadvantage. Otherwise, people will get married. And just after these two very good presentations, we have the new presentation of Rosa Maria Tristano, that is one of the family lawyer from the University of Palermo, and she is also a PhD candidate in our doctorate in dynamical legal system, and Rosa Maria will get married in 2 days. So my compliments, and I give you the floor.
Thank you. So before I start, let me say a few dutiful words to thank Professor Salvatore Mancuso, who involved me in this conference and association, which I'm honored to take part as one of the younger of all the participants, and our chair, Professor Miranda, whose teaching inspired this first step for my research, and of course, Professor Moroto, all the organizers, and the other speakers, Professor Pace, Professor Amiel, and all of you who are listening. So, the colleagues who speak before me show us with their interesting presentations 2 different dark sides of family law, which may result from legal or non-legal factors that affect the family by extension, like the religious context or tax law provision. But even family law itself has its dark sides. In fact, sometimes it may happen that a rule which is considered effective and useful at the time of its amendment may be affected by the passing of time and become useless or even counterproductive. Now, if possible, I will share my screen with my... Okay. Okay, I hope that you can see. So, regardless the persistence of the binding value of the law rule, it is truly perceived as right by the people only when it reflects their needs, and it gets complicated when it is outdated or connected to an obsolete sociocultural and economic background. It's the well-known difference between the law in the books and the law in action, which is expressed by the difference between the law rules that are enforced and their interpretation and practical application. That's why we are talking about obsolescence as one of the dark sides of family law that is for sure one of the branches of private law most dynamic and sensitive to different influences. Family law, in fact, sheds its root in the concept of family, that is not a legal institution, but a social one that is pre-existent. It has been defined as an intimate domestic group of people related to one another by bonds of blood, sexual mating, or legal ties that has been a very resilient social unit that has survived and adapted for time. But this definition was very different 10, 20 or more years ago and has changed over time to this result. We don't know how long it will remain adherent to reality, nor we can actually know it at the moment. The peculiarity of this subject is a real challenge for every legal system, which has to deal with it and pursue a correspondence between regulatory issues and constantly evolving concepts. Each of them has a different approach, and that's why a comparative look is particularly attractive. In Italy, family law has been one of the most frequently reformed branches of private law. But every time after each reform, wasn't unusual to read that nothing had really changed. And still nowadays, we know that there are gaps to be filled or particular situations or figures not adequately protected. A nice metaphor that I read that describes this situation is the story of an explorer on his way to the North Pole on his dog sled. He ran on the direction verified on his compass, covering many kilometers, but checking the map at the end of the day, he found out he was farther from the North Pole than he was in the morning. The reason is that he was running on a huge iceberg, which was going to the south faster than he was able to go to the north, but he couldn't understand it and kept on running. Well, Italian family law is like the explorer seeking in vain to regulate a society that in the meanwhile is running faster and in the opposite direction. Maybe the solution could be change method, instead insisting in the same direction. Well, the rise to the North Pole of Italian lawmaker starts in 1942 with the Civil Code. The social context to which it referred was traditional and patriarchal, partly influenced by the fascist rigor and with a strong religious component. Families were focused on the pivotal figure of the man, husband and father, and marriage was indissoluble. The code aimed to satisfy public interests, mostly economic, privileging the certainty of family relations and therefore also hereditary relations at the cost of sacrificing individual freedom to the conservation of the marriage bond. The most important reforms of family law take their effect in the 70s. Their purpose was dual. First, they want to adapt the traditional scheme of family law to the new principle guaranteed by the Constitution in 1948, giving effect to the idea of moral and legal equity of spouses, for example, operating on the legal regime of matrimonial goods and abolishing the institution of the dowry. On the other side, they wanted to reflect the social revolution started in the 60s by introducing divorce and reforming filiation and adoption and family law in general. However, the evolution of family law of the 70s with respect to the 1942 one was nothing compared to the leap forward of the 90s and over. In fact, in the last 3 decades, inconceivable possibility have arisen. Internet has literally crossed the frontiers, and the simpleness of communication has facilitated the spread of habits, cultures, ideas, and scientific discoveries from one country to another, and even personal movements are easier and fast. And one of the results is that the idea of family has changed along with the society, moving away from a traditional pattern that no longer corresponds to reality. Today, next to the tradition of married couples, there are family of fact, same-sex unions, and extended families, even polyamorous, and also parenting has changed. For this reason, a new period of reform in Italy, A new period of reform in Italy took place from 2000 onwards through the enactment of a disorganic and uncoordinated set of statutes on topics such as simplification and streamlining of the divorce proceedings, full unification of the status of legitimate and natural children, medical-assisted procreation, same-sex unions and cohabitations. But once again, they crystallized a certain moment without taking into account the fact that the situation they wanted to regulate probably would already change after a short time and possibly present new aspects unthinkable before. This situation complicates the framework in 2 ways. On one hand, whenever people can find a remedy to their concrete case in the law, they may decide not to apply it, considering it useless, and look for a remedy elsewhere, maybe in a more favorable foreign legal system. On the other hand, the lack of adequate provisions may lead to an increase in the use of justice in search of clarifications, and the courts are in the uncomfortable position of having to force their interpretations as much as possible, compensating the shortcomings of the law with their decisions, which, however, in Italian systems have limited effect to the individual cases submitted to them. This is what happened, for example, with one of the most infamous Italian statutes, that is for sure the Human Fertilization and Embryology Act of 2004, which clearly shows how an act biased by policy reason and that doesn't reflect the social context remain empty words. The main consequence of this statute, in fact, is exactly the need for clarification and interpretation by the courts with the obvious burden of their works, and in addition, the race for a more favorable regime abroad. This debate is back current after the enactment of the Italian Same-Sex Civil Unions and Cohabitation Regulation Act of 2016, after remembering Italy's Sirina Act according to the Italian custom of calling an act with the name of the member of the parliament who proposed it. This act finally recognized other forms of family beyond marriage, cohabitation of fact and same-sex civil unions, but unfortunately it wasn't enough to settle the matter and left several gaps of protection. In fact, Italian parliament runs with the hare and that's with the hounds, or gives one shot to the circle and one to the barrel, as the Italian says. and trying to reconcile the pressure of opposing sociocultural groups ends up not satisfying almost anyone. Many questions have arisen on this issue, such as the exclusion of same-sex couples from the possibility to adopt children or have access to medically assisted procreation or to surrogacy that is generally prohibited. The issue is particularly sensitive, and the tradition and culture of each country has a very heavy influence on the law, and it's not uncommon that supranational courts deal with it, even if it doesn't always make things easier. For example, recently, the European Court of Human Rights and the European Court of Justice have ruled on this subject. And the situation is paradoxical because according to the letter of these decisions, a member state of origin which doesn't admit same-sex parenting, here Bulgaria, must recognize a parent-child relation between a same-sex couple and the son, born abroad with artificial insemination, only in order to guarantee their fundamental freedom of movement through the union and the exercise of the rights granted to all European citizens. That means that the issue of a passport registered to the child and bearing the names of both parents shall not be refused. But on the contrary, the same country, on behalf of its national identity, may refuse to record the names of both parents on the birth certificate of the child, which therefore doesn't match with his passport. Similarly, the other decision recalls the same need for balance between the proper limits of a legal system, in this case Iceland, and the protection of the child, stating that the state of origin of a couple may legitimately refuse to recognize its filiation relationship with a child born abroad after surrogacy, provided that alternative protection instruments are in place to preserve the minor and his relation with social but not biological parents, which are therefore not directly recognized and protected as such. And this is just one of many issues. Another one, for example, also common to France, that has similar rules and a civil law legal system like Italy, comes from the recognition of unmarried couples and families, explicitly stated, but less useful than it may seem. The rights actually granted, in fact, are nothing more than a fragmentary reformulation of those already consolidated by the courts, but the most significant prerogatives of a family, comparable to those provided for marriage, remain reserved only for those unmarried couples who decide to register themselves in a special list at the municipal offices of their place of residence. Only on this condition, in fact, they have the right to sign a partnership agreement specifying their contribution to family life and even their property regime. But isn't it odd that a couple which doesn't want to formalize the union has to formally register in order to protect its rights? Once again, the result is the poor practical application of this provision, formally innovative, but actually not in line with the real social needs. Maybe it would be more reasonable to state a framework of basic rights and principles for families, leaving the possibility to choose how to organize it and actually enhancing the freedom of self-determination of family members in their relations. This paradox is even more absurd if you think that unmarried couples have the possibility to sign a contract while the same possibility is precluded to married couples, who certainly have greater protection, but only within the limits set by the code, without being able to fully self-determine. In the Italian legal system, in fact, marriage is not considered a contract because of the alleged lack of its patrimonial aspect, and prenuptial agreements or other arrangements for regulating the relation between the spouses are not allowed, because rights and duties that arise from marriage are not disposable, and even the interpretation of the courts are fluctuating and can stem the debate in the absence of a regulatory intervention. Additionally, not considering marriage as a contract has procedural implications too. In fact, divorce and other family law proceedings are focused on the role of the courts, which are not even specialized. But very little room is left to the private autonomy of family members for the settlement of disputes. A useful tool in this respect might be the extrajudicial proceedings, such as mediation and the proceeding called assisted negotiation, we say negoziazione assistita, extended to family disputes in 2014, which, however, is still less used than the traditional consensual or judicial proceedings, as shown by statistics. Also because its application field is limited in the intent to prevent prejudice for the most vulnerable part of the relation, the weak spouse or even more children. And another limit of a very practical and non-technical nature lies in the fact that during a family conflict, after the failure of the very first attempts at agreement, the possibility to submit the matter to the court is almost always favored by all the parts involved. In fact, each of the spouses hopes to obtain the right satisfaction that they believe rightly or wrongly, but always firmly to deserve. And lawyers, from the other side, rarely have the honesty of discourage a client who want to propose a judicial proceeding, certainly more lucrative than a mediation. It's sad, but it's true. Obviously, these are just brief suggestions, and each of these topics deserve a dedicated deepening that we don't have time to face now. Anyway, they all share a common point. They are related to an outdated social context, which is actually more complex, and this obsolescence makes them ineffective. However, there are countries where the problem is differently and may be most successfully tackled. And that's why, as we said, a comparative look may be an interesting research topic. It is spontaneous to turn attention to countries that on one hand are similar in social, economic, and political structure, then that live the same ideological upheaval and have needs similar to the Italian ones, but on the other hand have a completely different legal tradition, such as Britain, where the case-based approach, typical of common law and legal systems, has particularly favorable consequences on the diversified and dynamic context of family law. The first remark concerns precisely the dichotomy between common law and civil law legal systems, which is useful to explain the difference of approach to family law and the very idea of family and its relationships. In civil law systems, like the Italian one, the legislative format is the main one, and statutes and codification are preventive tools used to give a regulatory framework to as many situations as possible. They must also serve as the only basis for the interpretation of the courts, which are bound by their application. On the contrary, common law systems approach is totally different, because they are case-based systems and the legislative format doesn't prevail on judgments. In practical terms, this means that in the absence of the prompt enactment of a provision regulating new situations, the courts can still consider them in a decision of the case creating a new precedent. This is by simplifying the reason of the slower adaptation and modernization of Italian legal system and its faster obsolescence compared to the British one. The thing about common law, in fact, is the role of the courts, which has a particularly favorable effect on family law, as it allows an elastic, practical approach, instead of seeking the classification of individual cases within categories identified and regulated by codifications and statutes. And from this comes the lower impact of the continuous innovations and variations that family law undergoes. Obviously, this does not mean that legislation doesn't have its importance in Britain. It is the expression of the legislative power of Parliament, which was considered traditionally to be able to do everything unless change a man into a woman and conversely. However, legislation operates in relation to case law, and the courts have the unique prerogative of conditioning the regulatory scope of statutes, giving them an interpretation, which has binding effect as a precedent. This does not mean that judges may overlap with Parliament's determinations or diverge from them, but they can exploit the tolerance margins offered, interpreting them on the basis of their prudent appreciation. An example concerns properly the already mentioned issues of same-sex couples and social parenting. In a recent case, a woman successfully applied for parental responsibility in respect of the child who was born before a same-sex relationship with the biological mother, and the family division followed a 1991 precedent which determined the 3 factors that the courts must consider to grant a father parental responsibility, that are the father's commitment, attachment, and the motivation for his application, and concluded that the same applies to a female second parent. She wasn't the biological parent and didn't fall within the provisions in respect of parental responsibility, but the court ruled in her favor, taking into account the specific circumstances of the case. And another typical example is Matrimonial Causes Act, which states that the only ground for divorce is the irretrievable breakdown of the marriage. But the true scope of this expression is concretely determined by the courts each time on the basis of the circumstances of the specific case. A typical feature of British family law, in fact, is the enactment of statutes which rather affirm fundamental framework principles, leaving to the courts the power to assess on a case-by-case basis, giving due prominence to peculiar and different circumstances, and ensuring more adherence to new social needs. This guarantees the effectiveness of family law over time, avoiding its premature obsolescence, as it can be concretely applied by the courts in the decision of cases, although the Parliament doesn't have enacted a new reform yet. Moreover, the approach of family law provisions in Britain is influenced by the basic assumption of the contractual nature of family, that remains a private affair of its members unless a situation of danger or prejudice occurs. And that's the reason why in Britain there isn't any statute which regulates the property regime of a family, nor the contribution of each of its members, which every family is free to regulate on its own, as in a contract. But there are instead provisions related to divorce, parental disputes, adoption, and other serious or emergency situations connected to family. Anyway, even in the pathological phase of the relation, like divorce, private autonomy is encouraged with the prediction of a mandatory mediation attempt, and the intervention of the courts is limited to serious cases in which the protection of the parties involved is compromised. Unlike what happens in Italy, for example, the disputes concerning the upbringing of children and the ones concerning divorce are two autonomous and independent proceedings, and only on the basis of an explicit request from the parent concerned and in the absence of an agreement, the courts rules on the matter. Our courts, on the contrary, must necessarily decide on the custody of children together with the divorce decision and cannot approve consensual divorces that do not provide for it, since this is considered prejudicial as always harmful, notwithstanding the specific case. Moreover, the new Divorce, Dissolution and Separation Bill, which will definitely become in force at the end of the year, follows what had been said about the contractual nature of marriage and the remedial role of the courts in family matters, and leaves even more room for the autonomy of spouses who will be able to make a joint application for divorce without the need to prove the irretrievable breakdown of marriage, but only stating it. And their joint statement will be conclusive evidence in order to obtain a divorce order. It's clear that the peculiarity of civil law systems affect Italian family law, that is more complex to update and certainly unable to keep up with the evolutionary and revolutionary process which nowadays involves the family. The identification of marriage in a contractual relations, which the parties are free to organize, bounded only by general principles established by the law, allows to leave to the private self-determination of the spouses the definition of the majority of family matters, and this would make it less necessary for the courts to enter into the merits of every family disputes, limiting their action to a serious and precise monitoring of the protection of the rights of the parties involved and of compliance with fundamental principles. Obviously, it wouldn't be reasonable to wish for a sudden change of course, nor for a transplant of a foreign model. But nevertheless now, as in the field of family law, there is a need for a drive toward privatization, even if balanced with a complete and structured framework of safeguards and rights, and the guarantee of the access to justice in every case of risk. Thank you.
Okay, lovely. Thanks a lot, Rosa Maria.
Thank you.
Well, I think that in Italy, but it's a problem that is very common to other systems. In Italy, we have a particular situation because the Italian family law was reformed in 1975. This means that from the present codification that was from 1942, passed around 33 years. Between the origin of the code and the family new family law, and we have yet this kind of legislation. So if you think that from 1975 until now passed more than 46 years. And of course, our society evolved, and the family now is completely different. The idea of family is completely different from the idea that we have in 1975, but the rules are always the same. So it's a very, very big problem. I mean, for instance, the question of who is the mother For a Roman law tradition, we think about the sentence that mater semper certam est, but in reality now, thanks to the artificial insemination, is the contrary. We have absolute certainty of the paternity of the father, but we cannot imagine who is the mother, because you may have a womb leasing, an artificial insemination by I don't know why, and so it's really incredible to maintain the rule in origin that is always the same, and not take in account what is the reality. And this, I think, is a big problem of all the question about the family law. Well, we have just a few minutes to start the discussion. So if anyone want to intervene, I have please, Annalisa.
Yeah, thanks. Only let me do a clarification because the so-called Chirina law that discipline same-sex civil unions and cohabitations, it doesn't contain any fiscal rules, but it's weird because thanks to interpretation, we can say that the same rules of married couples work for same-sex couples, because there is an equal formula that parified same-sex couples to married couples, but not for cohabitants. It is incomprehensible and is another dark side of law, only for this.
Yes, also because as you can see in the statistic, official statistic. Practically now we have a number of cohabitation that are more over the normal marriage, so or the regular marriage. I don't know if it's correct to say normal or regular marriage, but okay. The point is that people want to cohabit, but not married. So it's a problem. This is I think it's a very big problem too. And anyone who want to intervene? I have a question, but it's a general, but it's to Amien. And I think that, what do you think about the obsolescence of the law and the gap with the evolution of the society, especially in a country like South Africa, where there is a mix between the statute law and of course the legal tradition, the different tradition of the people?
Thank you for that question. So if I understand you correctly, you're asking if the laws in South Africa, the family laws, how responsive are they to the realities on the ground? Have, in terms of evolution, has the one sort of, and I think I think we've come a long way in South Africa. I think there's been a lot of development and a lot of improvement to recognize different kinds of family forms. I think we've been quite advanced actually in the way in which we've been recognizing different family forms, but we still have a bit of a way to go because in the process of law reform efforts to recognize religious marriages, they've not been recognized. Cohabitation relationships has not been legally recognized yet. We recognize polygynous relationships, but we don't recognize the right of women to take multiple husbands or multiple wives, or even husbands to take multiple husbands. So I think there've been developments, and I think, as Rosa Maria said, I think it's inevitable that family law has evolved in a particular way because people's it could not remain unresponsive to I mean, it in some instances takes longer than other instances. I mean, I cannot for the life of me imagine how it is that we are recognizing same-sex unions, but cohabitation relationships are not recognized, right? So it doesn't, in some instances, doesn't make sense. But then one also, realizes that the development of law is also influenced by external influences, and some of them are political, and yeah.
Krista?
Can I also ask a question for Waida? Accidentally, I'm at the Law Reform Commission Advisory Committee for the recognition of marriages and the Single Marriage Statute. So we are working together in that regard. You were referring to the Indian legal system and how the Indian legal system make provision for different types of marriages and regulate those marriages differently. But I remember when I did research on the different personal legal systems in India, that there was a concept which they called personal law shopping. So people would, a Muslim wife, for example, who cannot get divorced, would convert to Hinduism to try and get a divorce through that system, or a Hindu husband who is not allowed to have a second wife would try to convert to Islam to marry a second wife. So the fact that there are different rules for different types of marriages opens the floor or opens the door for this possibility that people start shopping around to see what is going to suit them best. But if you have a minimum core requirement saying that this is all you need to have your relationship recognized, would that not solve a lot of those problems? Because then it doesn't matter how and what type of marriage you concluded, your relationship is recognized for the purpose of family law. The consequences then would have to, and that is typically what you would be doing in your project, would typically look at the consequences. Should there be different consequences for all the types of marriages? I don't know, we struggle with that whole idea of having different rules for different groups when it comes to a marriage, and especially because it's also now the reason why some of the customary marriages, a husband would have some wives in terms of customary marriages because polygamy is allowed, but he would also marry a wife in terms of civil law. And when that marriage is dissolved, then problem starts because all the wives pops up and say, well, I was a wife in terms of the Marriage Act, I was a wife in terms of the Recognition of Customary Marriages Act, and the problem starts. So having different pieces of legislation for different groups, would that not worsen the problems?
It's almost as if the horse is bolted, Krista. I mean, we're sitting with several pieces of legislation already, right? And we're trying to consolidate. I think the effort is we're trying to consolidate them, but I think one has to ask the question: what is the potential impact of legislation, and what are the possible unintended consequences that could happen? And I think if you try to impose a uniform set of norms across all marriages, the difficulty is that you run the risk of ignoring certain practices that happen in reality. So I think there are certain norms and certain requirements that could be made uniform, that could be consistent. So, for example, the age of majority. I think it's almost a universal expectation that child marriages should not be permitted. I think in terms of legal capacity, the requirements for legal capacity could be made uniform. But even something like, and the requirement of free and informed consent from all the parties involved, right? But we know that the way in which that consent is derived differs in certain communities. So, for example, in the Muslim community, it is a common practice in South Africa that the wife conveys her consent via her proxy. And so she's not physically present at the marriage ceremony. Now, it can open up potential for abuse where she's not really given her consent, but her proxy goes ahead and conveys the consent, right? And in an instance like that, you would have to make provision for a proxy by marriage because it happens. Whether we like it or not, it happens. But in that instance, you could say, well, the marriage officer should then require her consent in person, and different arrangements can be made for that. So I think that there are ways in which one could try to be consistent with requirements across the board, but one has to also be attentive to the fact that there are nuances that are different, that if you don't make provision for it and you don't regulate it, that it could slip through the system. Yeah, so and I mean, I understand that the advisory, and by the way, Christa's being very modest. She is the chairperson of the advisory committee. So we're sitting with a top dog here. Yeah, so I think that's I mean, I understand the desire to want to try and bring uniformity across the board, because it kind of makes things neat and it packages them nicely. But the truth of the matter is that the way in which our marriages and our relationships happen in South Africa and possibly elsewhere as well, it's not neat and it's not uniform, and it's not, and so we have to pay attention to the diversity. And you mentioned the example of India. I mean, India is the perfect example. It is filled with a plethora of cases, of Muslim personal law cases. When I did my research on India, I was astounded at the number of cases that came up at high court level with completely differing interpretations of similar sets of facts. On the one hand, you'd have a judge saying a Muslim wife is not entitled to maintenance because she wasn't obedient to her husband, right? And he confirms that rule under Islamic law because the Muslim Personal Law Act has given the regulation to the Muslim community. But then you have another judge on the other hand saying, then that goes up to the Supreme Court, and the Supreme Court says, no, but this is anti-gender equality. But in the reality is that for that case, from a magistrate's court level to a high court level to eventually get to the Supreme Court, it takes long and it takes resources, and not all women are able to actually get to that level. And we are going to face a similar situation in South Africa if we don't try and pay attention to the diversity and the differences at the grassroots level already. And we have that opportunity if we are looking at legislation. It makes the job of the judge easier, because the judge can say, well, legislation is actually regulated here. It's not saying to me that as a community you can do what you want, so then therefore my hands are tied. In a way, it makes the job of the judge also harder, because now he has to do a little bit more work, or she has to do a little bit more work. But I do believe that at the end of the day, there is a greater potential for justice and gender justice than if we simply sit back and say, let's just treat everyone the same, because same is not always equivalent to equal.
Just to follow up, number one, the proxy is dealt with in this single statute that is proposed by the Law Reform Commission. And secondly, the Law Reform Commission is just is interested in the interest of the state in the existence of a relationship or not. So it is just important to get uniform legislation which would make it easier for to prove that a marriage exists. But the consequences, they must be sorted out in all the different legislations dealing with matrimonial consequences, such as the matrimonial property, succession, divorce, and so on. So if we have to wait till all that is regulated and included in one piece of legislation or an omnibus, whatever is decided, it's going to take a very long time. And all those religious marriages and other types of relationships will stay out in the cold until an agreement can be reached or what must be included in that legislation. And the other thing that I'm thinking of, the moment you start regulating religious and cultural norms in a piece of legislation, you fix it. So you don't allow for development of those religious rules in terms of modern requirements or needs of communities. And also the fact that, also in Islam, there are not consensus on what the content of those rules must be. So how are you going to put that all into legislation? Would that not be a better if it is almost treated like we treat common law? So a judge will, for example, be able to develop the common law if he thinks it is needed because there's a constitutional issue. But if it is a rule of Islam is fixed in legislation, would that not be more difficult for a judge to change if it is unconstitutional or against human rights?
Well, this is a very big question because, of course, it's the same for all human rights. And why, for instance, in Italy, we have no to eat our grandfather, like in some part of the former Borneo or something like this. It's a tradition to eat the grandfather when he died. But this is not good for us. I think that in some cases we should rediscover the idea of public order. That is a concept, not the international public order, but the public order that is very, very near to the rule of law, the concept of rule of law according to the common law, you know. And in this case, we can use the public order like a general clause in a manner that all that is not conform with the generality of the policy of the state or the group cannot be allowed. But it's a very, very complex question because we have to choose between the liberty and the civil liberty of all the people and the idea of rule that we have to follow. And so it's very, very complex. A friend of mine that is a professor of management, and he has a different approach from the economic analysis of law, told me that this is not a problem of what is the most convenient choose, but it's a problem of what the people think is good. So if a question, a rule, an idea, a statute is good for the people, and the society intend this like a good thing, this may be the way, the point, the focal point that we have to follow. But of course, it's a question, it's a very complex question, and I think that in this case we have to pay a tribute to the politics, because politics is over the law, not the contrary. Sometimes. I don't know if Agnese agree with me, but.
It is indeed not an easy, it's not an easy question to address at all. But if I can, you see, I think that there is an opportunity. So if we're dealing, the difficulty is when dealing with religion and culture, you're dealing with issues that really form almost the core identity of people, right? And so, and this is why there's this knee-jerk reaction against wanting to have the state intervene in that kind of arena. But the problem is that by having left the communities to regulate themselves, the conduct has emerged that has militated against women because of power dynamics and imbalances within relationships. So the state almost has to now step in and try and create some balance there. You're quite right when you say, can legislation regulate everything when it comes to religious marriage and cultural marriage? And I don't think so. And precisely because when Parliament is legislating, it is not just legislating human rights, it is legislating different interests in society. And Parliament has to then try to balance those interests as much as possible. And that's why in my presentation I said that you're never going to get that kind of legislation that is going to satisfy everyone. But this is why I think there's an opportunity for the courts to then come in and adopt and look at the legislation and interpret the legislation. We know that courts interpret legislation. And I think especially, and this doesn't go across the board, but certainly there is space in Islamic law, for example, where for one conservative interpretation, you can get a progressive interpretation. Almost everything in Islamic law, you are able to find a progressive interpretation. And that means that there's an opportunity for a secular judge to be able to draw on the religion itself, and not like in India where, and this is why there's so much chaos in India when it comes to these decisions, where you have non-Muslim judges wanting to interpret Islamic law. Instead of looking for the progressive interpretations in the religious law itself and drawing on that. So I think there is that mechanism that we can actually use in the context of Islamic law. You might not have it in other religious situations. But as I said, there are differing challenges and there are differing needs in the Jewish community, in the Muslim community, in the Hindu community, and in other communities. But so if you apply a one brush across them all, you're going to provide protection for some communities and you're going to miss out on other communities. I can't see how we can adopt a one-size-fits-all approach when there are so many different communities with different needs and different challenges. And I completely agree. We're not going to get 100% right, and there's going to be a hit and a miss. But if we have the opportunity to pay attention to the nuances now, so for example, you give the example of the proxy. Yes, the single marriage statute, the draft legislation does include proxy, but it makes no provision for the marriage officer to ensure that he gets the consent from the woman herself. Right? And those are the kinds of nuances I'm saying that we need to pay attention to, that you don't want those kinds of gaps to get missed. There may be some things we can't regulate, that we actually then just have to hope somebody brings a challenge in court, right? That they could take up in court. But for those aspects of religious and cultural marriages that we can regulate, we should. And it's especially because we have the opportunity to provide that protection for women.
I understand. And in Italy, speaking about the interpretation of the law, in Italy, a very, very famous president of the Council of Ministers said that usually we, in front of a law, we have to interpret the law for the friend and strictly apply for the enemies. And I think this is a very, very, very point that is strictly applying now. Well, anyone want to have a question or propose a question? No, not yet. Okay. Well, now it's time to go. Thank you for all. Thank you for the speakers. Thank you for the people that are attending this session. And see you again we hope in very, very soon, but in presence and not like this, because it's a fantastic way to have the possibility to work from distance, but it's not good for the friendship. So we hope to see you all of you possibly in Palermo next time or everywhere. Thank you again, and see you again.